You have legal questions. Amy the attorney has the answers. Welcome to today's show. And here's Amy.
Hello and welcome to Amy the attorney. We have Alison Kort here today. She is a Kansas City lawyer who specializes in appeals, among other things. She has other practice areas, but what we are going to talk to her today about is appeals. And we're just going to get right to the heat of the matter. Let me ask you this. What is an appeal?
Okay. An appeal is a proceeding in front of a higher level court than the trial court where one party is dissatisfied, or both parties are dissatisfied with the trial court's determination below, and so they wish to appeal that decision, but appeals have to be based on an error of law. So it's not a do-over.
Okay, so let's go through the courts so the viewer can understand what the different courts, and we're going to just stay in the state of Missouri for now. If
Sure.
it's similar to the state of Kansas and to federal court, we'll talk about that in a minute, but we're just going to talk about the state of Missouri now. Tell the viewers what are the three different courts, and then we're going to get into what you can appeal.
Okay. The circuit courts are the lower level courts that from which the Court of Appeals will take appeals. I'm sure there are other lower courts, but I'm just going to talk about circuit courts for the meantime. So a circuit court judge, or in family law, a commissioner, makes a decision. And in Missouri, the Court of Appeals has three districts. They are the Eastern District, which comprises of St. Louis, and surrounding areas, and the Western District, which is Kansas City, and then the Southern District, which is closer to it's kind
Springfield.
of near Springfield, exactly, Springfield. Yes, so those are the three courts of appeals, and neither one of them is they're all at the same level of hierarchy or precedential value. And then there's one Supreme Court of Missouri, which sits in St. Joseph.
So you would go from trial to appeal to Supreme.
Appeal. Yes. And Missouri is kind of unique in that if the the Supreme Court doesn't just take appeals. You have to petition the Supreme Court of Missouri to take your appeal, and they can decide which appeals they want to take. Something somewhat like the Supreme Court of the United States. It's my understanding that the Supreme Court takes 15% of cases that are where an appeal is requested, and that is done through what we call either an original jurisdiction. Oh my goodness. I'm so sorry.
No problem.
So I'm on my Mac, so the phone rang.
Gotcha.
But that the court, okay, so what was I saying? 15% is taken through an original proceeding, or what we call a writ of transfer, as in the case is transferred from the Court of Appeals to the Supreme Court. And one thing that's unique about Missouri courts in that regard is that if the Supreme Court takes a case that had been decided by the Court of Appeals, the Court of Appeals opinion goes away entirely. And so the Supreme Court takes it as if it came directly from the circuit court level.
Okay. All right. That is good to know. Okay. So you had mentioned earlier, you said you don't get a do-over when you're doing an appeal. You said it has to be an error of law. And I want you to give an example or several examples of an error of law so that we can understand what that means.
Sure. So in law school, we've all learned about standards of review. And at the trial court, you have standards of proof, right? So criminal is that the prosecutor has to prove beyond a reasonable doubt. In most civil cases and in injury cases, it's preponderance of the evidence, which means 50% more likely than not. At the Court of Appeals level, if you're dealing with, there are several different standards of review. The one that's best for the appellant, for the person who's appealing the decision, is de novo, meaning anew, which is that has to do with interpretation of of an area of law. So, for instance, something that's interpretation of you cut that out. So interpretation of statutes, for instance, or interpretation of of common law, as in what the court has said. So, for instance, if we're looking at the Missouri Human Rights Act, which is much like Title VII or the Civil Rights Act, prohibiting discrimination on certain bases, right? So we've all heard recently in the past couple of years about what on the basis of sex means. So one thing that has been an issue is, what does the word sex mean? So does it mean gender? Does it mean gender identity? Does it mean biological sex? Does it mean sexual preference? So recently the Supreme Court of the United States came out with a determination that I think they did that sexual preference, so sexual orientation, was a basis on which employers could not discriminate. But a question is still in the works as to transgender litigants and whether being transgender is encompassed within that meaning of sex as it is in the statute. So that is de novo review, meaning that the Court of Appeals will take different opinions, will take different arguments and different opinions and kind of determine what that word means, or whether the trial court correctly defined it in the case below or not. More commonly, so that's de novo review. More commonly is the abuse of discretion standard, particularly in Missouri, which is extremely hard to meet. And this is an issue I have frequently with people coming wanting to appeal a case. So you asked me initially about what happens, about why it's not a do-over. But people come to me and say, hey, I don't like what happened. I want to go to the Court of Appeals. And the abuse of discretion standard means that the lower court basically abused its power, abused its discretion. And I've often, when I was teaching, I likened it to, there was a Seventh Circuit opinion where the judge said to find an abuse of discretion, the court opinion below must hit us as wrong with the force of a 5-week-old unrefrigerated dead fish. So
okay.
I know. I'll throw it in there on occasion, but then you can't do it too much because it's like, okay, she's always going to use this. I actually explained this to my daughter, who said, actually, Mom, it should be like a 3-day-old unrefrigerated dead fish, because by 5 weeks, the fish is completely disintegrated. I said, okay, fine. You're too smart for me. But so that's what I tell people is I say, is it so wrong that it is wrong with with the force of a 5-week-old unrefrigerated dead fish? And in Missouri, the standard is for under abuse of discretion is that there was not substantial evidence to support the decision, or it was against the weight of the evidence. That's a different challenge, which means that even if there was enough evidence on the record to rule the way that the court did rule, the evidence supporting the other side was so overwhelming that the decision was against the weight of the evidence. So these are very, very hard challenges to meet.
Okay, I'm going to stop you there. I want you to give me an example of de novo, just a real life example of a de novo, whether it was your case or not, and a real life example of abuse of discretion.
Well, I gave you the de novo one.
Oh,
that's the sex one.
Okay, yeah. Sorry.
Interpretation of statutes, let's say, yeah. And well, actually, I'll give you one that I did in Missouri. Okay.
All right.
It didn't actually get filed, but I used to, and still do on occasion, write briefs, kind of ghostwrite for the ACLU in Missouri. So one question we had was about parenting rights. So it was 2 female partners, and one of them had given birth to the child, and then they never got married, even after gay marriage was legal. So there are 2 ways to become a parent in Missouri and in most states, and either one is biologically and the other is by adoption. So if you don't do either of those, all you really have, according to the statute, is you can file is nothing. You have no parental rights. You can file for visitation rights, but when you don't have rights as a parent, even if you raise that child. So for instance, in our example, I represented the non-biological parent, and the non-biological parent and the biological parent had been together for many years. They planned this child together. They chose the sperm donor together. They were in the hospital together, etc. They never did get married. And then when the child was 5 years old, the relationship went sour, and the biological mom left and said, "That's it. You can't see our son anymore." So the interpretation that I was trying to get the Supreme Court or the Court of Appeals to adopt was this concept of equitable parentage, which is what does it mean to be a parent? And so various other states have interpreted the word parentage to include functional or equitable parents who are neither biologically related to the child nor by adoption, but have, for all intents and purposes, served as that child's parents from the beginning. So that's a de novo review, does this term parentage include equitable parentage? And that means that the Court of Appeals can look at different decisions and essentially decide what the law means. So that's de novo. An abuse of discretion case, I recently had another custody appeal, but this was between a biological father and a biological mother. So the court, to determine which parent has custody, it's an 8-factor test in Missouri under the statute, especially when dealing, like whether it's joint legal custody or sole legal custody, joint physical, sole physical, although nobody really gets sole physical custody anymore. It really has to do with legal. So the circuit court below had determined that the mom, who was my client, was entitled to sole custody of the child based on these 8 factors. And so the court found according to that lined up with each of those factors. And those factors are the wishes of the parents, the wishes of the child's adaptation to the child's community and environment, et cetera. And then one of the big ones is which parent is more likely to provide frequent and continuing contact to the other parent. So the court determined these factors to weigh in favor of my client, and that's an abuse of discretion issue because so the dad appealed it, and we went before the Court of Appeals, and at that point, the Court of Appeals is tied in that they're not going to reopen evidence. They don't re-examine credibility of witnesses. They don't re-examine the evidence. They say, okay, this is what the court found. You're not asking us to change or interpret the law. You're just trying to say, hey, the facts don't match up with what the court decided. And so the Court of Appeals will say, we defer to the lower court for decisions regarding credibility of witnesses and determination of evidence. And so that kind of appeal is very, very difficult to prove. So that's an abuse of discretion. Okay. And in that case, it was brought on the basis of against the weight of the evidence, meaning that the father had argued that the evidence weighed in his favor as the parent who was going to be more likely to allow frequent and continuing contact to the other parent, and not in the mom's favor. But in fact, the Court of Appeals wasn't going to decide that because they're not going to say, they will, if there's zero evidence, they will, but they're not going to say, hey, this evidence is here on mom's side, this evidence is here on dad's side. Let's reevaluate and see which fact we should find. So that's an abuse of discretion.
Does everybody who appeals a trial court decision get the opportunity to argue and actually do the whole appeal? Is that a right? And tell me about, does every person get the chance to do it?
So certainly it depends on the jurisdiction. And I know that we're talking about Missouri here. So the Western District, which is where I practice, pretty much will take any appeal as long as there is a colorable claim as long as there's something that could be that could have a different interpretation below. So and you asked about arguing. There's one chance to argue, and that's at oral argument. And oral argument is very, it's sort of the last ditch effort, because you can't say anything in oral argument that you have not brought up in a brief. So everything has to be already discussed in your briefs. So the Court of Appeals is actually very kind and generous in Missouri. They will, when I was practicing in New York, they don't want, you have to beg for oral argument. So once the briefs are all submitted in Missouri, if the court determines that it doesn't need to hear from the attorneys on any of this, the Court of Appeals will send basically the "we don't want to see you" letter, but it's much nicer than that. It's we've determined that this case can be resolved without the benefit of, we don't need oral argument, and then any party who wants oral argument has 10 days to request oral argument from that point. And then they will, if you request it, then it gets scheduled. That's in the Western District. I don't really know about the Southern and Eastern, although I would imagine the process is similar.
When a client comes to you to talk about an appeal, what would you say about the timeline of an appeal? And yes, we're sticking to Missouri, and we can extrapolate to Kansas and federal later.
Well, what I tell them is that it's a lot of hurry up and wait, and then once you get on the train, it goes, and that's it. So again, so custody cases actually there are certain cases that are expedited that have less, that go faster, and custody is one of them. But for the majority of cases, in Missouri, a judgment is final 30 days after it is entered. So frequently I'll get calls and it's after the 30-day period. And at that point, so between 30 days so after the judgment's final, the parties have 10 more days to file a notice of appeal. So it's really 40 days since the day the judgment is entered. And there are circumstances under which the Court of Appeals will permit late notices of appeal, but I've done it before. The Court of Appeals will do it, but it requires a special, it's an application for special permission to file late notice of appeal. So it's just more work to do it. So the notice of appeal gets filed in the circuit court, and then that is sent to the Court of Appeals. And then from the date of the notice of appeal, the appellant has 90 days to get the record on appeal together. And the record on appeal is the legal file, which is all of the documents that were filed in the circuit court. Well, not all of them, the relevant documents that were filed in the circuit court. And that's actually a whole different, it's become super easy to do that. And the transcript, the 90 days is really so that the transcript folks can get it done, because that takes a long time. And sometimes they get it done fast, and the transcript organization is straight out of St. Joseph, so depends on their load and what have you. So after that 90-day period, then the appellant's brief is due 60 days after that. The respondent's brief is due 30 days after the appellant's brief, and then the appellant gets a reply brief 15 days after that. And usually people ask for at least one, maybe two extensions of time for the same period of time. So I usually tell people it's a year from the date of deciding to appeal until it's resolved. I've had really good, it also depends on when the court schedules oral argument. I had one oral argument that was scheduled in May, even though we had finished all the briefing in December. So it was a long time later. But generally speaking, the Court of Appeals, once they get it, I have found that they issue the decision fairly quickly, much faster than circuit court decisions in some ways, because they're very scheduled with how many they take in a given time period. So that's usually what I tell people as far as time frame. But frequently what happens in terms of costs is that I'll enter a notice of appearance and then nothing happens for a while, because we have that 90-day period, and then we have another 60-day period, and then all of a sudden it's boom, 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 and that's all I work on. So,
okay. I want to circle back around to some terms you used, and I want to make sure that the viewer understands them. Talk about the parties that are part of an appeal and what happened to them at the trial court.
Okay. So in the trial court, you have plaintiff, defendant, or petitioner and respondent.
Okay.
Right. So I think, I'm thinking in Missouri, are they always petitioner and responder, or is that just in certain cases?
As far as I know.
It could be a plaintiff, right. It could be plaintiff, defendant, right?
Yep.
So you have the plaintiff and defendant, and on appeal, the party who appeals is whoever lost at trial, and that person is called the appellant. This is in Missouri only. That person is called the appellant. So it could be defendant appellant, it could be plaintiff appellant, but I usually just call that person the appellant because it gets really confusing.
Okay.
And then the party who's responding to the appeal in Missouri is called the respondent. Okay. So there is the use of the word respondent at both the circuit court level and the Court of Appeals level. And it's for this reason I usually like to call them by whatever title they are, or even names on some occasions, because it gets confusing as to who is who in the parties. So if you're whoever lost then becomes the appellant, and then whoever is on the other side is the respondent. In federal court, in Kansas, in other states, that person is called the appellee, or if you want to be franche, it's the appellee. So, it just, but in Missouri, it's petitioner or respondent.
Okay, great. The other question is, when is a judgment final? I guess I don't, okay. You have a certain amount of time. Uh-huh. That doesn't mean the day the trial ends, right?
No. It's actually, it becomes people. It's more confusing than it needs to be. So the day that the judgment is issued, right, starts the clock. So if, for instance, if you're at trial and the judge says, okay, we're done, and then takes 9 months to issue the decision, that decision, the date of entry of the judgment, starts the clock, and the judgment is final 30 days after that date. And then 10 days after the judgment is final is the time period for filing a notice of appeal. So okay. The judgment's final 30 days later, and then you have 10 days.
Okay. Tell me about the cost of filing an appeal. Again, we're sticking to Missouri. I know it can vary.
Sure. Yeah, it depends. It really depends. It really depends. So I usually will, if I'm dealing with an individual, I will quote that person. So I would say that to the appellant is always going to be at least a third to a half more expensive than the respondent.
Okay, that makes sense.
Because you have to file, first of all, you have to come up with everything. You have to say, here's why it was all wrong. Whereas when you're the attorney for the respondent, you know what their arguments are, and then you respond to those, and you kind of can do your research on, affirmative issues from that. But when you're just taking it from the trial court, it's a lot more work. So I usually quote people at about $50,000 for an appellant and around $25,000-$30,000 for a respondent. It just depends on, how much research goes into it, how much hand-holding your client needs.
That makes sense. So when someone hires you, then they say goodbye to their trial lawyer, the person that represented them?
That's a good question. No, I don't think so. So first of all, I think they say goodbye to everybody that I've worked with so far. I mean, I've only been, I only opened the firm 2 years ago, even though it was my 20th reunion this year. Of the appeals that I have been in contact with trial counsel frequently. So I'll call trial counsel and ask questions because what happens is I read the transcript, and that's what I have. That's my understanding of what happened at trial. That and all of the papers that were filed in the docket. So, but if I really want to get a sense, like a, just, like a, for lack of a better word, like a spidey sense of what these people were like, what the judge was like, what the attorney's feeling was. Was the judge like more seemed partial or had any ill will towards one side or another? I will be in touch with trial counsel, and I find that to be really good. And then every time I do it, when there was a trial counsel below, that person always comes with me to oral argument, and that's kind of fun.
Sure.
Yeah.
Do you do both civil and criminal appeals?
I have.
Okay.
Most of what I do is civil. I've done a case for the Missouri Public Defender's Office, just to, as a contract attorney. I did a criminal appeal there. Criminal appeals are hard because everybody gets a right to an appeal. You get an automatic right to an appeal if you've been in jail. And it's very difficult to defend a defenseless case. So I've had that experience. I mean, certainly there are tons of cases of wrongful conviction and, but like the Midwest Innocence Project does a lot of that. And there are other organizations that do that, but just to get an attorney to do, to fight on your appeal, it's hard. It's hard. And then if you have someone where you think there might be a legitimate case, they don't have any money. They're in jail. They don't have money. And that's part of the system is, they're usually under people of a different economic class and status and financial, et cetera. We all know about that. So
yeah, definitely. Is there a cost besides the lawyer? Is there a cost to an appeal?
I see. I think there's a filing fee. It's like $70 or something.
All right. But other than the lawyer fee and then the filing fee?
No.
Okay. That's good.
It's all lawyers. Oh, wait. I lied. The transcript.
Oh, yeah.
The transcript is ridiculous.
In terms of money.
Yes. It's very expensive. It's a complete monopoly. There's like one company that does it and you have to pay for it. Yeah. And if you don't get a transcript, I mean, when people take their cases on pro se, they frequently don't understand that they have to get the transcript from the lower court. So an audio recording, which is kind of what Missouri does, is insufficient. You have to send it to St. Joe. And so you have to get the audio, you have to have it transcribed. And, it's definitely, if you've had a day or two of trial, it's definitely a few $1,000s. So that's part of it. But otherwise, it's just like any other case. You don't have to pay a special amount to do it.
Okay. And I asked about it earlier and I wrote it down of how to say it, but what is a writ of?
You got it.
Pronounce it. So I'm just going to talk about it. Yes.
Well, that's an appeal to the Supreme Court. So, but it's an appeal to the Supreme Court of the United States and the Supreme Court in other cases. So in Missouri, it's just a motion for transfer. Okay.
Not that fancy word.
Not the fancy word. Certiorari. You know what I'm thinking? I don't even know what it means. I should know. It's a word, but it basically just means it's a plea to the court to here's why to take my case. Please take this case. And in Missouri, if you're in the Supreme Court, you have to be able to show, in order to get the Supreme Court to take your case, one of that 15%, you have to be able to show that it deals with a question of law that's relevant and it like what is the word? It's a question of importance and relevance in Missouri at the time. So it has to be like, what is the greater good for the reason that we're going to take this case? Okay. That's important. Yeah.
When you are writing your appeal on behalf of your client,
yeah,
what all is going into that? Do the facts matter in an appeal as much as the law, or is it a combination of both?
It's definitely a combination. And it also depends, again, it depends on the standard of review, right? So if I'm dealing with an abuse of discretion standard, which is most of them anyway, but that's most appeals. Because more people are going to say, hey, I don't like what happened. Not, I think the law is wrong. Not, even though we would love to have it, not every case is Brown versus Board of Education, right? Not every case is separate but equal, or, ending Jim Crow or something, or a Obergefell, which is the gay marriage, like all that amazing stuff. We might get like a touch of that, but it's not, it's most of it is like, I don't like what happened. Right. So, Missouri has very specific rules about how to structure the brief, as do most states and the federal courts. So the statement of facts comes first, and you can't argue the statement of facts. So, but again, it's one of those skills where even though you're not arguing about what happened, like you can't say, I'm just thinking, you can't say the court wrongly did X, Y, and Z. That's for the court incorrectly ruled that blah. That's argument. You can't do that. So that's a blatant form of it. But there are ways to structure the facts, which we've all learned in law school as well, like start out with your good facts, put your kind of hide the bad facts in within paragraphs, or try to minimize them by placing them in certain parts of the brief, but you have to show the fact. In Missouri, you have to show facts that give the court a complete and accurate understanding of what happened. So that's the rule, essentially. And people mess with that all the time, actually. And usually that happens, by people I mean attorneys who write it, or try to either skew it, or what happens frequently is omission of facts, because it's easier to omit bad facts than it is to characterize bad facts as good facts or hide them. But that's not okay either. But people do it all the time. So,
right.
All right. So that's the facts section. So yes, it matters, because that's actually the first thing they read, right? Is they're like, here is not always. So in Missouri, you have these awful things called points relied on. You remember points relied on?
I've tried to banish it from my memory.
Well, I never liked the concept because basically they're point headings of the points that you're going to make in your argument. But points relied on, I'm thinking, like, why are we ending that phrase with a preposition? It makes me crazy. But Missouri, I'm like, how could there be a thing called points relied on? That's what we're going to call it. But okay, never mind. So, and essentially there are rules for doing the points relied on. It's kind of like under does when in law school we say, like, under this law does the trial court correctly rule for the petitioner when X, Y, and Z happens, as in fact. So what they're trying to say is in the points relied on is, according to the law, how did the trial court do it wrong and why? So it's basically including all of your arguments within your points. So the first thing the court's going to read is your points relied on. Then, so they know what your arguments are. Then there's the statement of facts. Then they read that. Then they're going to read the points relied on with the argument attached. So you have to in a brief, you have to put the points relied on twice. So you have to put it first, the facts, then the points relied on, then the argument. But it's all there anyway. So then by the time you get to the argument, you're saying, okay, here's the standard of review, and here's why the lower court did either the right thing, so we'd say the trial court erred in determining blah, 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 or we do the right, or we say the Court of Appeals the lower court did the right thing, did the wrong thing, the court erred, or when I get animated, or did the right thing, as in the court below correctly held blah. So, and then, people tend to put in the kitchen sink, and it's interesting because it's my belief that really you should only include in your argument points that your best points, and let the rest of it go. They don't want to read an 8-point brief.
Right. Would there be any, once somebody has taken an appeal, and we'll continue with the family law case, the dad didn't like how the case turned out, and so he is appealing, is there a minimum response that the wife respondent has to do? I mean, or is there's no way that the respondent / wife can sit it out? Like she has got to hire a lawyer and
Yes.
play ball.
Mm-hmm. I mean, when you say there's no way, I suppose theoretically that a party could bring an appeal and there could be no response at all, and that party will still lose. I suppose that's possible.
Okay.
And
I'm just thinking of situations in criminal law where the prosecutor puts on their case, the defense says we have no evidence because they don't feel like they have won the case in their, the prosecutor has not proven its case, and they're going to argue to the judge or jury and pick apart whatever the prosecutor put on. But no way is that going down in appeals. They have got to respond to what the appellant is arguing in the brief, or
I would say that it would not be advisable to not hire a lawyer about that. But certainly it happened. People can't always afford one, right? I mean, certainly, or and there's even, and that's why like in a criminal case, the defendant is always gets a right to an attorney in an appeal, because you're going to jail. But so I would say that even if you're the respondent and you have to go pro se, it's better to do that than to do nothing. I'm trying to think if I certainly have never participated in a case where one party just flat out didn't do it, didn't show.
Right.
But sometimes it will happen where the respondent will not file a brief, but then they'll go to oral argument, or it's a good question, and I don't really know the answer. I don't really know the answer. I can't think of it's kind of like this. If somebody sues you for $80 million, are you not going to respond?
Right.
I mean, or hire somebody to do it,
And this is a larger question of the law in Missouri, and I don't know the answer to. Mm-hmm. I hope you do. Is there ever a situation where somebody's attorney fees are going to be paid by the other side?
That is a good question too. So I've dealt with this quite a bit. So yes. So first of all, if the statute the way it works in Missouri is, if there's a statute or part of a contract that provides for attorney's fees on appeal, then yes, one side will get the attorneys. Well, one side has the potential to get attorney's fees. But particularly if you're talking about a fee shifting device like Title VII or a 1983 case, like police brutality, like against a municipality, any of those remedial statutes that provide for fee shifting will also do it on appeals. In family law, it's interesting. So in a divorce, in a divorce or child support or custody case, the lower court has discretion to allow, to permit one side to recover an amount of attorney's fees that's reasonable, and et cetera. So, and that is true in appeals also, except that you have to file for attorney's fees in the circuit court and not in the Court of Appeals. So for instance, if I'm trying to obtain attorney's fees for my services on appeal in a family law case, I have to go to the trial court to do it. And then you have to prove there's standards for it. So it's who has the ability to pay, what the assets and debts are from the divorce, who filed the appeal, what the attorney's rates are, and the rates and time, and whether they're reasonable for the community, and the merits of the case. So that's, and I've done some attorney's fees in family law cases.
Okay.
Mm-hmm.
what is something that I have not asked you that you feel like people should know about appeals? Is there anything I missed?
Other than it's not a do-over. I think that, I'm trying to phrase this correctly. It's very hard. I mean, it's very hard to explain to clients what are questions of fact and what are questions of law. Sometimes it's hard for lawyers to understand the difference too, me included, especially if you've got a combined question of fact, question of law. And just because, if the court's decision below was unfair, that's not a legal standard. So even if it's unfair and it's a bad result, that's not appealable. And I think that is what is so difficult for folks, is they're like, but look, it's so obvious. It's so obvious. Here's what happened. And then I didn't do this and I didn't do that. And I can't believe the court treated me this way or whatever. Is that, judges are appointed / elected on the basis of their merits and ability to do their jobs. And so Missouri trusts them, or, so the governing agency, the state, we instill in them that ability to determine cases. And so to go on appeal is a lark. I mean, I will only take an appellant's case if I think there's a real mistake. And I think how much it costs, because people think, oh, wait a minute, you're just writing papers and then you go to court once, right? But brief writing takes a long time and it's very intensive and it's hard. And you have to research all the different cases and say, here's what the law says. I have to fit our facts within this framework. So I think it's also, here's another thing. It's much less adversarial than trial work. And that's actually one of the reasons I love it. Is it's much more about what does the law mean? And, and how are we going to interpret it? And how does it apply in this case? So, for instance, when I said earlier about using, stating the facts without argument, it's interesting to see trial lawyers who I will work with want to embellish on the facts. And I have to say, no, because we're just taking the facts as they are and saying, this is what happened below. And we all know that facts aren't truth, right? So facts are what the lower court finds. Are they truth or not? It doesn't really matter for purposes of appeal. So that it's much more of a trying to interpret whether the lower court made the right call and less about I'm right, you're wrong.
It sounds like you probably are having tough conversations with clients and potential clients at the outset, because even though it's immersive and you are going to have to figure out all the points, in the end, you are kind of giving them an overview at the beginning of saying, I don't think the law is with you. I'm willing to fight for you, but understand that the chances of success are low or something. I mean, it sounds like you're having those conversations early.
Well, actually, I will say, if I think I can't take it and I'm not willing to fight for you, then I say I can't do this. I cannot take your $50,000 because I know you're going to lose.
Right.
I once had a potential client who, was not educated in the law, let's just say, who said to me, I want a guarantee. And I said, I cannot give you, I was kind of shocked. I was thinking, how did you go through the trial process and not understand that if anybody could give a guarantee, we would all be out of a job.
Right.
You just go to the court and buy it, right? So I had that conversation. I said, not only can I not give you a guarantee, but I would be very skeptical of anybody who did tell you that they could get you a guarantee. Right. I think, and one of the hardest conversations is when the client asks, what are my chances? and I will tell them what I know statistically. But in terms of particularly my response, so on the other side of it, right, my respondent clients who won at trial and now they have to go through this appeal process, they're terrified about it generally, is they're going, oh my God, I thought this was over. And now here I get this notice of appeal. And what does that mean? And now I need to shell out this more money and blah. And I have to get a new attorney because most trial lawyers don't want to also do appeals. It's too much. You can't handle your docket. And also, I mean, I don't have that many cases at a time, like 2 or 3 at a time. Is that, many people who have trial lawyers who have a docket of a bunch of clients can't possibly have the time have chunks of time where they can just map it out for only brief writing. I mean, sure, if you have trial, then that happens, but it's a different ballgame. I would say that writing briefs and doing appeals is akin to the preparation stages for trial, is in terms of focus and concentration and how much time it takes. So I would say I spend a lot of time trying to reassure my clients that it's extremely difficult for the other side to be able to prove their case. Yeah. And the other thing about it that I found interesting, it's a very small bar of attorneys who do what I do, particularly in Kansas City. And for the most part, we all know each other. We're on the Appellate Practice Committee, but we see each other all the time because, I guess it's with any niche area.
Right.
So it's hard to get, people say, oh, who does appeals? And there's really not that many folks who do it. So,
right. Well, I think being a part of a collegial bar is very attractive to me. The criminal law bar is very collegial in terms of other defense attorneys and prosecutors. There's rarely situations where it's really ugly. I can't say the same for family law. I feel
not
like
at all.
Family law bar is really
mean. I've found that. I have found because I started getting into family law a little bit, because I did a family law appeal and I have a couple of family law cases, and I am frankly kind of astounded at how it works with the other, I don't mind the family law, but I do mind the family law
lawyers,
particularly when I think rules are optional. Deadlines are optional sometimes in family law. I'm going, what is this? Why did they say that we needed to file this by time? So that's another thing about appeals, is that the rules are the rules. And I like that. It's get your stuff in. And if you don't, there's no grace period. There's no nothing. And you have to apply for it. And I like that, because then I know that my opposing counsel is going to comply with the rules the way that I'm going to comply with rules. And if you don't, your stuff gets rejected, and you only get, if you're the appellant, you get 2 shots. You get the opening brief and the reply brief. And if you're the respondent, you get 1. So don't not file your documents.
Right. Well, and I feel like in family law, sometimes they take on their, the personality of their client or associate me with the personality of my client.
Right.
And I'm I'm not my client. So, I've done 2, and then I was like, no way.
Family?
Yeah.
Yeah. I think I'm going to try to get out, because this is really all I want to do is appeal. But,
and you can tell you have a passion for it. And,
although it's funny, Amy, I know that we talked about education law last time, and I had this amazing Title IX mediation on Friday, and I was like, oh my God, if I had that, it was incredible. It was 8 hours long, and it was just the Department of Education did it. And it was, it wasn't all amazing, but to watch my client just be a total badass. It was just, and she was a kid, right? She was 19, 20. I was just so impressed by the whole thing. But Yeah, so that stuff's fun too. But I would like to get more appeals that are involved, that are in areas that I love like that. Like that would be, if I could like put it all together, I would do like discrimination stuff and, like women's issues and education and, like that's what I would, and like civil rights, that's what I would do. But in the meantime, it's very, it's good when I get to know my clients really well. And that's partially personality. My personality is that I get to know them, but also I'm asking them I'm reading the transcript from the trial. I ask them all kinds of questions. I give my clients a lot of homework because it's, first of all, cheaper, and secondly, easier for them to go through I'm like, here's the transcript. I want you to go through it, and I want you to note everything that I should look at. Because if we're looking at a 600-page transcript, I'm not going to catch it all, right? So they always do. They do that, and then and I say that, and also tell me where this was, like where something was wrong, right? Tell me in the judgment what was correct and what was not correct, and what evidence supported that and what evidence didn't support it. And I find that the more involved my clients are in the process, the better the better they feel about it, the more confident I feel about it. And, and I end up so they're with me for that year and they're stressed, and they get to, and I get to know them pretty well. And so it's fulfilling in a different way than trial work. It like, yeah, it's, plus they already know about the litigation process because they've been through it. So it's not a big surprise. Yeah.
This may seem basic, but if you settle, you give up the right to appeal.
Correct.
Okay.
Well, I mean, in the settlement, you say that I'm done, no more suing, right? Certainly there's like breach of settlement stuff, but no. If you settle a case, no. If you settle at trial? Yeah.
I'm just saying, just in general, if you've settled a case.
Oh yeah, if you settle the case, it goes away. And I think some people actually do try to use an appeal. I mean, it's not a bad decision to encourage settlement. Is that, okay, I'm filing for appeal. I'm filing a notice of appeal, and if you're willing to work with me, we'll settle it and it'll go away. And yeah, that's what happens. Sure. Because everybody knows that, like, here is another giant chunk of money that you're going to have to pay, as well as time and not knowing. And one other thing that you didn't ask that I'm thinking about is that if there's a money judgment, right, it is very hard to stay the judgment. So, I mean, I think people have differing schools of thought on this. So if you don't have enough money to post say it's a divorce case and one party wins $60,000, okay, from the other side. So that means that the way that the bond statute works here in Missouri is that in order to stay that judgment, the appellant has to put up a surety bond in the amount of the judgment plus costs on appeal plus interest for a year. So it usually turns out to be quite a bit more than the actual judgment itself. And if you're just a person, it's really hard to get it unless you have a yacht somewhere.
Right.
It's like, so, and if that happens, then, and you aren't able to stay the judgment, then the person who won, so the respondent on appeal, can go and collect it. And then if that person then like flies off to Tahiti and it's gone, even if you win, you have like there's no money to get.
Right.
So it's hard.
Okay. That's good. That's good to know. So you would be expected to pay the judgment plus.
No, you pay the bond.
Or pay the bond. Yeah. Okay.
Yeah. You pay the bond. And it's a weird statute because, for instance, I'll stop this. But so let's say for this $60,000 case, right? Part of it was, is that he let's say he gets the house in the judgment, but if you don't, so let's say the only asset that he had was the marital house, but because the judgment is being stayed and is not executed, he can't use the house for collateral. It's tied up in the judgment. Yeah. So in some ways it doesn't really make sense because by the very act of appealing the decision, the assets get frozen, but then the other side can still collect if you can't post a bond separately from that. So bonds only really work if you're very loaded or a big company.
That's tough.
Yeah.
It would make you want to settle, like you said.
Yes. Well,
urgent.
Yeah, I mean, if you're the respondent, I'm thinking, I mean, it doesn't, right? Like if you're the appellant, yeah, you want to settle it, but what's the other side's incentive? So if I appeal, I mean, the other side's incentive is that they no longer will incur the attorney's fees and have to go through the process, right?
Right.
But they're under no obligation to settle it, and they're under no obligation to if the appellant can't get the bond, then they're free to go collect the judgment. So they just they can either go, but I tend to not do that because if the assets really aren't going anywhere, I kind of think, well, okay, why collect? Because you get interest on the interest is 9%. So you'll get the interest when the judgment's final after the appeal.
Is that interest rate, and we're going to end after this, is that interest rate in a statute, the 9%?
Yes, it is. I kept thinking where, I don't remember exactly, but yes, it is. It's 9%, and it changes, but it's 9% on judgments. Yeah.
Yeah, that's good. That's a healthy chunk.
Yeah.
Allison, thank you so much.
Thank you.
I'm very excited. We'll be able to cut this up and put it on the YouTube channel. I'll let you know when that happens. And
awesome.
Hold on, I'm going to end recording, but I do want to chat with you real quick.
Okay.